Okay. The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. We will begin with the prosecuting team, given 10 minutes, and afterwards, the defendant's team can also make their arguments for 10 minutes. So prosecuting team, you may take the stage.
Okay, so let me start. Okay, so our thesis is Supreme Court case Layshock versus Hermitage is about one student's action of parodizing a profile of his school principal in MySpace, which is the homepage, just like the SNS. And this became a problem as a school suspended Justin Layshock and banned him from graduating high school. The trial mainly discussed the freedom of speech and press that is granted to everyone in the United States. And since creating a MySpace profile is about out of reach of the school, and we believe that the court cases of Justin Layshock is innocent. And so first argument for our team is that according to First Amendment, the Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition. But actually, in this case, everyone are granted to the First Amendment, which is the freedom of speech. But yeah, just the Layshock is same case because he also just expressed his own freedom, like of speech to the world by using the homepage called MySpace. But the school just suspended him, even though it was like a out of power of school, and even though the school also like sued the student before like suspending the student, but the police said they have no like the student have no like guilt for like they should not be like suspended, but the school just suspended by their own power, even though the national law didn't make them make like any penalties to the students. So yeah, first of all, I think the school just regulated the First Amendment, and it was a cruel penalty to the students. And like there will be a supporting detail from our other teammates, who is maybe Ujay.
Okay, what the family of Layshock proposed to the court was that there were three major infringements in Justin Layshock's punishment. The first one being is that Justin did have the First Amendment right, and that has been violated. And the second infringement is that the district policies were vague. And the final infringement was that the district punishments interfered with Justin's family's parental right to how to best raise, nurture, discipline, and nurture a child. So adding on to Selman's point of breaching an individual's First Amendment, back in the 18th century, there was a similar case of turmoil between the freedom of speech and libel. So Peter Zenger was a newspaper writer who wrote an article on how the governor of New York was corrupted and was guilty for numerous reasons. And Peter agreed to be on trial, and he exerted his defense of free press and claimed that truth is a defense against libel, which isn't written truth. And this trial is known as the Peter Zenger trial. And at the same time, the English common law, which had been transported to the colonies, provided the truth that no defense was an accusation of seditious libel, and truthful information could be even more dangerous than lies. And the importance of this case is that it sort of established the principle, which is now firmly embedded in the U.S. law, and that truthful information cannot be wrong. And Alexander Hamilton, one of the founding fathers, also used this argument in the case of People versus Croswell when defending Harry Croswell against the criminal libels of accusation. So I believe that the district's response to the students' conduct transcended the protection of freedom of expression, which is guaranteed by the First Amendment, because the district cannot establish a sufficient nexus between his speech and a substantial disruption of the school's environment. And as the First Amendment is already written, it cannot tolerate the district stretching its authority into his grandmother's home and reaching him while he's sitting at her computer after school in order to punish him for the expressive conduct he has been engaged. So Justin's use of the district's website did not constitute entering the school, and the district was not empowered to punish him out of school, which is out of the school's control. Thank you.
In addition to Jess' opinion, I want to bring out one other case named Tinker versus the Moore Independent School District, which is a case that held in 1969. This is a case that Supreme Court that happened in Supreme Court that the High Court upheld the speech of rights of students who wear black armbands to school to protest the war in Vietnam, famously noting that the minors don't shade their speech rights at the schoolhouse gate. The reason I bring this case is that this is the most famous case that that can prove that if there is no substantial disruption in educational process, the school cannot block the independence of rights of students' opinion, and in this case, in order to justify the suppression of speech, the school officially must be able to prove that the conduct in question would materially and substantially interfere with the operation of the school, and I believe this Supreme Court decision will support this case, layshock and hermitage case that previously. The Supreme Court made decision that if there are no disruption in educational process, the school cannot interfere the student's opinion. Yes, thank you.
Okay, thank you. We'll go over to hear the argument of the defendant's team.
Okay, teacher. So can we also refute to some arguments of prosecutors this time?
You may, but
Okay.
prosecuting team cannot answer until they're given their rebuttal time.
All right. So let me go with my argument first. So regarding the same case, layshock versus the school, we are defending our client school. So yeah, first we think that layshock's behavior was a violation of personality right, morality, and school law as well. So first, it was a definite violation of personality rights. Here, the personality rights refer to the right of an individual to control the commercial use of one's identity, such as name, image, likeness, or other unequivocal identifiers. So in this case, layshock, for no doubt, used the principal's image, and name in the parody. So yeah, it was definitely a violation of personality rights. And second, it was a disrespectful behavior towards principal, and it's considered inappropriate considering the school's moral conduct laws. So in school, the principal is the head of the school, when thinking about the administration policy, but it was a disrespectful behavior undoubtedly. And third, it was misbehavior in the school district must be punished by the school law in the first place. So school law, like according to the school law, the student should have been punished as he was. So yeah, that was our team's first argument, and I want to make a counter argument to Mr. Sungmin's argument. According to our intelligence, Sungmin actually said that layshock used some inappropriate profile picture, and because it was outside of the school, it's there's no relation to the school thing. But actually, layshock didn't make any profile picture, but I believe it's another case. Yeah, like I believe it was like it's another case named JS versus Blue Mountain School. So yeah, it's not related to layshock. So please make your own argument to cover that in your time. And yeah, I believe the prosecutor team is making some fake fact in this holy court. Thank you.
So adding to Joanne's argument, now our team's second argument is that it is the school's right to punish the student, punish the student who did immoral actions. So it was the government's choice to pick the school as a place for the school members to educate students, not only to educate them through classes we learn on each subject, but also teach them manners and what they should not do and what they should do. So, for example, punishments are given for decreasing the amount of undesired behavior by the students. So it depends on the situation and type of the punishments. If the punishments are at like low level, it can help students to build their discipline. So the punishment for a student in school is to not punish them like severely, but to punish them to make sure that they won't make the same mistake in the future. For example, this case, layshock didn't make any financial profit from this parody. If he made a financial profit from this parody, he may have be sued by the school's principal, but it was not for this case. But however, if layshock was not punished for this current case, he might be a future criminal for making these parody date that brings up profit from these parodies. And also I want to also counter argument on Sungmin's words. So Sungmin said, does this case like layshock making a fake profile, like a parody of his school's president was out of the school. But however, although it was out of the school, it included a school member in school. So I think it's not totally unrelated to school. And that's our team's second argument.
So our team brings the another similar case of layshock versus hermitage, which is Kowarski versus Berkeley County Schools. So the specifics of the case is that Kowarski, who was the student of Berkeley County Schools, posted the Students Against Slut Chirps on myspace.com dedicated to ridiculing a fellow student. So the school administrator suspended her from school for 5 days. So after the suspension of the school, the student accused the school, claiming that the defendant violated her free speech and due process rights under the First and 14th Amendments. So the conclusion of the case is that the appellate court determined that the student's First Amendment claim failed because the nexus of her speech to the school's pedagogical interest was sufficiently strong to justify the action taken by administrators in carrying out their role as the trustees of the student body's well-being.
And moreover, the court held that the speech was materially and substantially disruptive in that it interfered with the school's work and collided with the rights of other students to be secure and to be let alone. And it was foreseeable that her conduct would reach the school.
I'm going to stop you right there.
Yeah.
And now the prosecuting team will have 5 to 8 minutes. First, if you guys have a rebuttal or you have some questions you want to give to the defendant's team, you may do so very briefly. If not, then I'll give it over to the justices to question the prosecuting team. So does anyone from the prosecuting team have anything to rebut against?
Yeah, I have a thing to say. So there is, I'm gonna rebut to Juan's arguments, and he claimed that Justin layshock did not create the profile, but there is also evidence in the record that the profile created by Justin was also viewed by other students in school. So this occurred on the Thursday of December 15, 2005. So teacher Craig Antouche observed students congregating and giggling in front of Justin's computer in a computer lab class. And teacher Craig Antouche also took a glimpse into Justin's computer and saw that Justin created a fake MySpace profile of the principal.
Okay, I'm gonna stop you right there. Do you guys have any rebuttal against the defendant's team's arguments?
Like additional arguments? Like it is not for Juan, but can I go?
Whose argument is it against?
Youngjin.
Go ahead.
Okay, so can I also ask a question right now? Like
he will be able to answer during his time.
Okay, so well, Youngjin said like there is a relationship between like this court case and the school, but then let me know what kind of direct damage the school has caused by this incident, Youngjin. Later
Okay.
on.
We'll stop here. Justices, you may now question the prosecuting team.
Teachers, you're saying justice is not defendants, right?
Yeah, the justices are
Uh,
questioning the prosecuting team. They may ask for any clarifications or further explanation or any new aspects about this case that would help them in making a decision.
To Ujay, I have a question.
Hajun, can you speak closer to the mic, please?
Okay. Is it good? Or wait.
It's good. It's good if you just talk closer. Oh, now we can't hear anything. Maybe Serin or Chonghyun could go first.
Then I have a question for all of the 3 prosecutor team. Is that one of the prosecutor had mentioned that there was no disruption in the educational process. Then is there's like a part, an evidence where layshock had not disrupted the educational process in certain point?
Prosecuting team?
Could you reiterate your question?
I was just wondering if there has been like an evidence or maybe a factor of there having no disruption in educational process.
Because there's no evidence that this case disrupt the educational process, it means that there is no disruption in the educational process.
Okay.
Also, this case is like between the actually this is for like principal versus the layshock. So like even though there is damage, it is not for the school. It is for like just directly to the principal himself. So like as you ask, like the educational process, there will be no damage because it's just like a one by the directly damage. It might be just for the principal. So
Okay, Hajun, can you ask your question, please?
All right, all right. I have a question for Ujay because he said that the district policies were vague. Then by what reason did you say that is vague? Because I don't know why it is a vague thing. So can
Ujay, you have a
answer that?
minute to answer that question and then we'll move on to the defendant's team.
So the district, there were no clear rules or sort of fixed rules on the punishment of Justin. So Justin was a pretty good student according to research, and the school so punished Justin for the school prohibited Justin from attending his regular classes and instead requiring him to attend an alternative education program where he does not have access to teachers. Also, although it was not written in the school law, the school also prohibited Justin from participating in various school activities, including but not limited to academic games and middle school tutoring. And finally, Justin was also denied from receiving full credit for his first semester classes.
Okay, thank you. Defendant's team, do you have any rebuttals against arguments made by the prosecuting team?
Teacher, like I have the answer for Sungmin's questions,
Go
but
ahead.
I forgot his question. Can I just ask him the question again?
Sure. Sungmin, what was the question?
So you said that there is a like the damage for the school, but what
Yeah.
kind of damage it was there? Because like a direct damage, not like a like the yeah, it should be like a direct damage for the school because not
Okay,
for
Youngjin,
like
can you
a
answer?
principal is himself.
Okay. I understand what Sungmin is trying to say. So, for my research, I looked through the internet and I found out that layshock was the agitator for the schools, ruining the school's atmosphere. So starting with layshock, other students also began to create these parodies of their school principal. So this ruined the atmosphere of the school, where the school had an atmosphere of respect between the students and the teachers. So I think it was a proper way for the principal to punish the only layshock because he was an agitator of starting this bad bad parodies to students, and other students also follow layshock doing this, and yeah.
Okay, thank you, Youngjin. Justices, any questions for the defending team? You guys have 5 minutes to ask the defending team their questions.
Okay, so I have one question to attorney Tim, which is you guys said wait, so layshock's action, the MySpace document uploading the pictures was happened in the off campus, so he was not in the school, and it was happened outside of school. Then is the school has a policy or rights to make punishments on students by their actions on off campus? So do they have any rights to punish them if
Okay,
it was
defending team.
happened in off campus?
I'm not really sure that the school has a specific law about that, but I think that it doesn't matter like on and off the school because you know, online it means that it can, you know, anyone can access them anywhere, you know, like off school, on school. So I think it doesn't matter like really much, but I believe that the school atmosphere really got worse because of that, because of the parody, because, you know, anyone could have access to parody, like in the classroom, in the bathroom of the school, in the cafeteria, anywhere in the school, right? So yeah, it must have been really fatal to principal's image. Yeah.
Any other questions?
So the attorney team said that the punishment can be the kinds of the education for the student, but do you think is the punishment is proper, or isn't that too much, or yeah? So I just wondered that is that proper?
Youngjin?
Yeah, I'll answer to that question. So I think it depends on other. I don't think there's like a real right answer to whether this punishment was severe or like light, but I think it was a proper way for punishment because Layshock was the first one to create the this parody, and other students also follow Layshock to create these parodies. So I think it was a punishment not to only punish Layshock because he's like a bad student or something, but it's to stop these painful parodies that breaks the atmosphere of respecting between the students and the teachers. So I think it was like not more like a punishment, but to like cut the way of the students making these parodies. Yeah.
Okay. Thank you, both lawyer teams and justices. We will adjourn. We will stop our session here, and we'll adjourn later on for the justices to deliberate and then announce their final decisions. Yes, so I will stop our session over here.